Eric, and allow me, like the speakers who preceded me, the use of the floor to thank SCCA for the perfect organization of this important event, for giving us the honor of being here and speaking to you today. The organizers proposed to me to address the impact of UNCITRAL standards in promoting the harmonization of international arbitration, and that by nature would bring us to a different perspective and a slightly more general way of looking at international commercial arbitration in the context of this conference. The body I represent is a commission of the United Nations that reports to the UN General Assembly, and we may ask ourselves, what does the United Nations have to do with commercial law, and why is it concerned with commercial law? And the answer is very simple. We firmly believe that good commercial relations promote friendly relations and peace around the world, and that's why we've been involved in this for a very long time. The first involvement of the United Nations in arbitration is, as you know, the New York Convention of 1958 on the enforcement and recognition of foreign arbitral awards. Now, the starting point of this work is basically to fill the vacuum that still exists today, that caused by the absence of a multilateral mechanism for recognition and enforcement of court judgments. We trust foreign arbitral awards. The world still does not trust foreign court judgments. Now, international trade needs quick and effective settlement of disputes, and that's why you have an international mechanism for the enforcement of foreign arbitral awards through the New York Convention. This has also been followed by another important development, which is an increasing role of arbitration also for the settlement of domestic disputes. We've heard some reference to that in the opening panel this morning, the fact that the parties may choose arbitrators who have the required expertise for adjudicating the sometimes complex and very technical subject matter of the disputes that appear before them, concerns about the length of judicial proceedings, but also the flexibility that is given to the parties in choosing the institution, appointing the arbitrators, and also steering the proceedings, obviously within those limits that we heard in Andrea Carlivari's presentations. So this is why there's been a constant work on arbitration, which has not only remained at the New York Convention, moved on to follow work on the UNCITRAL model law, international commercial arbitration, about which I'll say a few words in a minute. But let's just see this very quickly. These are figures from 2016, but these are figures of the ICC court. Only one that year, 966 cases filed, involving 3,000 parties from 137 jurisdictions. That's a very significant statement. I'm not adding here also the statistics of the AAA and other institutions, just to single out that one. Now, this is today's reality. But it was not long ago that very few countries had the capability of handling international cases. If you look back at the year the UNCITRAL model law was adopted, 1985, there were only 65 institutions in 43 jurisdictions that were handling international commercial arbitration. And if you look at those groupings, you see that the vast majority was in Western Europe. Now, years passed since the adoption of the UNCITRAL model law, 30 years after that. We have now 65 institutions countless institutions actually you have countless institutions in 126 countries that are capable of handling commercial arbitration, including international cases, also including Saudi Arabia, a country that was not present in that list years ago. This is a significant development, and one which we would also like to believe that has been also supported and promoted by the existence of an international legislative standard that was developed in a neutral process counting with the participation of countries from all major legal systems at the various levels of development, as happened to be the case in the UN Commission on International Trade Law, UNCITRAL. Now, in doing this work, we have focused on the role of law to support arbitration proceedings. And then we look at it from two different levels, and you see that reflected in the model law. Arbitration involves also, to some extent, a very delicate dialogue between the arbitral tribunals and state courts. We heard also about that in the opening panel this morning, the remarks made by His Excellency, the Minister of Justice of the Kingdom. The role of legislation is exactly to shape that relationship in a manner that the courts will support the arbitral proceedings and also not interfere with them in a manner that respects the party autonomy, the freedom that the parties express by choosing arbitration, which is also a point that was referred to by His Excellency, the Minister of Commerce and Investment, and the role that arbitration plays in enhancing the investment climate in Saudi Arabia. So it is important for the law to set the limits by providing for the legal recognition of the arbitration agreement, for the non-interference with arbitration proceedings, and limiting the grounds for review of arbitration awards. At the same time, courts may support the arbitral proceedings not only by helping the constitution of the arbitral tribunal, but also by refraining from exercising jurisdictions when, in case where the parties have agreed to subject their disputes to arbitration, by providing assistance by issuing in the enforcement of interim measures issued by the arbitrators, and also enforcing the final award. I will not dwell on the development of the model law itself and the origins of purpose, but basically the idea was to offer the world a neutral standard that could inspire domestic legislation, and we do believe that we have achieved that goal. And it's based on these three essential pillars: the party autonomy to organize the proceedings that determine the applicable rules, the non-interference of state courts with the arbitration proceedings, and limited review by judicial courts of the arbitration awards. Those three principles, if you, at least the last two principles, if you will, find their original inspiration already in the New York Convention of 1958. Now, if you look at the status of application of the New York Convention, sort of the model law nowadays, the New York Convention itself already has 159 signatory states, which makes it the most successful commercial law instrument in the world. The model law is now, and there's a typo in that slide I note, nowadays has been enacted in 80 countries that represent 111 jurisdictions, if you consider that each province of Canada and Australia is a separate jurisdiction, as well as the special administrative regions of Hong Kong and Macau within China. Now, the model law by itself has become a standard for, and you can read these quotes in the slides that will be available to you, has become a standard for measuring the quality of a domestic system for international commercial arbitration, but also, according to studies by the World Bank, is regarded as a standard for foreign direct investment and promoting foreign direct investment in the country as one of the factors that promote confidence in domestic investment. And this is why we're so happy to note that Saudi Arabia, and to count Saudi Arabia among the countries that with the 2012 Royal Decree have effectively enacted the UNCITRAL model law. Dr. Ziad Khoshain, who would follow me, would certainly address more concretely the relationship between the domestic Saudi law and the UNCITRAL model law, but we do consider that it is an enactment of the model law. And I would simply like to point out that not only the Saudi law limits interference by the judiciary, upholds party autonomy, but also upholds party autonomy in a particularly interesting way in that it allows the parties to choose as applicable law not only state law, but also through Article 5 to subject the relationship between them to provisions of any documents, model codes, or international conventions. So it doesn't necessarily have to be a treaty that is already in force in any particular country. That's a particularly modern way of looking at applicable law, and a particular liberal one. And we're certain that with events of this quality and more public awareness and training programs as SCCA is developing, these provisions would be applied in a manner that forces confidence in arbitration in Saudi Arabia. Thank you very much.